So hi, everyone. I'm Dale Branda from Stewart Advisors. I'm going to turn things over to our presenters right away. But before I do, I wanted to just introduce each of them to you. Our guest and our primary presenter today is Maritess Bott from Bott and Associates. She's been practicing law for over 25 years in the areas of estate planning, probate, and trust administration. Her passion is helping families protect their wealth and preserve family relationships. She resides in the northwest suburbs of Chicago with her husband, Gary, 22 years, and their children, Zachary, Nathaniel, and Jocelyn. Helping to moderate the session will be Mike Kwan. Mike is a principal with Stewart Advisors, and he does comprehensive financial planning and advises on investments. Mike works on a fee-only basis. He tries to bring clarity to his clients' personal finances and give them peace of mind knowing that they're addressing some pretty complex issues with thoughtful choices. Mike's interests always align with those of his clients. Mike also lives in the northwest suburbs, and he has 3 adult daughters as well as a growing group of grandchildren. Mike and Maritess know each other well. They've done a lot of presentations like this over time. So with that, I'm going to turn things over to them and we'll get started.
Okay, thanks, Dale. And Maritess, welcome. You know, our clients work and save their entire life to build assets so they can live the future life they desire and help support those family members that they truly care about. They also want to protect what they've built, but making time to plan for what happens to their stuff after they're gone is often a low priority. Their kids or nonprofits receive the future benefits, not themselves, and maybe that's why that happens. And we all know that life is very complicated. I've run into a number of different client situations that I thought I would mention a few of those today. Perhaps you've got adult children, now they're married. What happens if you leave money to them and they get divorced? Does that son-in-law or daughter-in-law get your future assets, and would that be okay? Our health condition, hopefully it's good now, but that can change at any time. That can apply to you, a spouse, a child, and that has implications. I've seen many times where parents make gifts to their kids at Christmas or during the holiday season, and then I've had conversations where they've said they don't like what the kids or one of their kids has done with the money, and they don't voice their feelings, and that certainly can cause quite a stir. And I had a situation a number of years ago where I said a spouse had passed, and there was an adult daughter who was married, but it was a kind of a shaky marriage. And I said, well, what would happen if you dropped $1 million or $2 million in a lump sum into your daughter's lap at this point? And she almost fell off her chair. And they had a plan, but it was a joint trust. And if you have young children and you don't have a will, and something happens to you and you're no longer there to take care of your kids, who makes the decision on how your kids will be brought up, and who's gonna raise them? These are all reasons to take action and implement an estate plan customized to what you want and take care of the people in your life. So, Maritess, I have a question. How expensive or what kind of penalty is there if you don't have a well thought out and updated estate plan?
Well, first of all, thank you for having me. I appreciate you and Dale inviting me to do this. If you don't have an estate plan, the default is always going to be more expensive for the family, both on time and money. The cost of going through a court system called probate is, I always round it to starting at about 5,000, going up to 10, maybe 20,000, depending on how many people are fighting. And then if you don't have something and you become disabled through a stroke or dementia, you'll go through a guardianship, which again is more court costs, more lawyers, more things that you have to spend money on. And that can go, that can cost quite a bit, 10,000 to start, and then every year you pay an attorney to keep it going. So it's one of those things where the default will generally cost a lot of money for the family, and then also just the time and emotional toil on the family as well.
And wouldn't you say that if most people knew what the consequences were of their inactions that they would choose to do an estate plan and put everything that they really would want to have happen in writing?
Yeah, definitely. I feel like it's always hindsight is 2020. If people can see through the future and have that crystal ball and kind of see the hardship that their family has to go through, they would absolutely do it now and today. It's usually families who've seen like a parent, a grandparent, an aunt, somebody who's passed, and they see their cousins go through it or a family friend go through it. It's just one time. It only takes one time to see somebody go through it that you realize, oh, I better do something for myself.
And what kind of stress is created when maybe there's not a plan, or they don't know, they're trying to pick up the pieces because mom or dad has passed, and they're not sure where to find stuff or what to do. And do you ever see, the kids and siblings get into arguments and even fights about what's the best way to approach things? And can you maybe just talk about that for a minute?
Yeah, absolutely. Stress levels certainly can be pretty sky high depending on how much fighting there is amongst the family. So many couples come to me and say, my kids get along, they're perfect, and nobody's going to fight. I think you don't intend like in-laws getting in their ear and having their own opinion. You have certain family members who said, Mom promised me this asset, the house, or this jewelry piece. So sadly, it's one of those things where you don't know until it happens, but if you can at least put the instructions now and try to reduce it, then it's even a better situation. I have a quick example is, sadly, I had a client, had 14 children. She was going into surgery, which was supposed to be routine, but she had some changes in her trust, and she told her daughter, write this down, and she had this amendment that she wrote at the hospital, and then sadly she passed away. We are still in litigation, not me. They are represented by a litigator. 14 children fighting over a $600,000 estate, and there's 4 lawyers being paid on it, and they're still fighting over all these little things. And I get so sad because we had done the estate plan properly, and then she wanted to change it up. So it's one of those things where I recommend, if you have any changes, talk to your attorney.
Yeah, thanks for sharing that story, and I'm sure you have plenty more to share with us. And I think you have a case study that kind of illustrates some different issues and what you can do to avoid some pitfalls and get a good estate plan in place.
Yeah, exactly. I like to share stories because I think it really drives the points home. And so I'm going to share my screen. I'm going to share a little just case story. A lot of things that I know you, Mike, have seen, Dale, have seen a lot of things happen in your own practice of people kind of trying to handle an estate when there's no estate plan done, right? And so today I'm just going to share a few things with a sample couple named Bill and Mary. But the first thing I want to share is what are some of the concerns that most people have? So these are very common. You might be on this webinar because you're thinking of these issues. You don't want the government to be involved in your personal life, your estate plan. You don't want to pay Uncle Sam any more money, right? We just finished paying Uncle Sam on income taxes, but why should you pay more for estate taxes, capital gains, anything that we can try to avoid? A lot of things on paper, a lot of people also worry about nursing home costs. We all know that we can plan and have this great retirement account, and then as soon as one of you has a diagnosis, then it might be one of those things where, oh no, how am I going to take care of him or her? We have to start spending down the money for nursing home. Number 4 is one of those, I don't want other people to kind of mess with my kids and try to get access to them and take advantage of them. So when I think of a predator, it's the Bernie Madoffs of the world, right? We know there's plenty of them. He was maybe the top person that was on the news, but there's so many people out there trying to take advantage of your family members. So it's important to kind of keep everything private so that nobody needs to know what your family is inheriting. And then number 5, of course, clients are always worried. I don't want my kids to fight. I want them to still see each other when I'm gone at Thanksgiving and, still have their, their family get-togethers. And unfortunately, I think you probably have seen this, Mike, where people like to stop talking to one another. They're so mad about mom's estate and how it was distributed that all of a sudden they're not even seeing each other or talking to each other. So that's a horrible, I think, result. So I say money is important. Let's preserve it. But I think relationships are just as important, and let's try to preserve that as well. So like I mentioned, we're just going to do an example so that you can understand some of the common pitfalls and then also understand how we can get peace of mind. So the Jones family is our example. It's Bill and Mary. They're a typical kind of couple who've retired and done some estate planning. Their kids are John and Susan. Susan was the older child, is married, has a couple kids. John is the younger one, not quite as established and going about his life. So Bill and Mary have a lot of options when it comes to their estate. Certainly they could take all of their money and spend every last dollar, which sounds good, but we don't have the crystal ball. That's just their tongue-in-cheek. But I do tell my clients, you're not required to give an inheritance to your kids or to anyone for that matter. So a lot of people have this fear of spending too much money and not give anything to the kids. It is your money. Number 2, they can die intestate, and that's really just a fancy word for dying without a will. And the last statistic that I saw was around 65% of people have nothing written down. That is why we have a very big, caseload in probate, especially in Cook County. So when you die without a will, the state of Illinois actually has created a will for you. It's called the statutes. So it means if you died and you have a surviving spouse and you have children, then 50% goes to the surviving spouse, 50% goes to surviving children. So that sounds maybe okay, but why should the children get money if the surviving spouse needs 100%? And then secondly is, what if you have a blended family? So then 50% goes to your spouse now, and then 50% goes to previous, children from previous marriage. And what if you don't have that relationship anymore? If you don't have either of those relationships, then we find, so if you only have a spouse, it goes 100% to the spouse. If you only have children, it does go 100% to children. If you have neither of those relationships, it'll go to nieces and nephews so actually siblings and parents first, and then after that, other heirs at law. So it'll get to somebody, but I would rather put down your favorite charity, your favorite niece, your favorite, the people that are dear to you, rather than random people that will be found through the intestate laws. You could put everything in joint tenancy. That's very common. So clients come to me and say, well, I'm good. I have everything in joint tenancy. My house is in my, in my name and my son's name, and my accounts are with my daughter's name. And so I'm good. And it's true. They do get the funds upon your death automatically. So that's just that's how joint tenancy works. But my cautionary, my caution about that is just be careful. So if I put my son on my property, sounds good and easy and simple, but let's just say my son and I have a falling out and I want to sell my house. And now I have to call him if I haven't talked to him in a while and say, son, I got to sell my house and you got to sign here. So he may even say no, right? He has he has control over your asset and it's not even his. And then the other negative is if my son decides he's going to, party a little bit and drinking and driving and there's a car accident and all of a sudden somebody is suing him. So my house is 50% owned by my son. That lawsuit can file a lien on my property, even though my son is not necessarily the joint owner where he paid for it. So that's a scary situation. I generally say don't put people on joint tenancy except for husband and wife. That's usually my rule of thumb. You could create a simple will, which is fine. It's at least a start. And what I say with that is it at least tells us who you want the money to go to. But in Illinois, if you have at least $100,000 of assets in your name, then we have to go through probate, which is that court process. I will talk a little bit more about probate in a couple more slides, but definitely a will is usually not enough. You can create a trust. So there's two types. Bare bones living trust is really somebody prepared a trust on their own and they didn't transfer anything into it. That's really important to transfer things into it. You have to create a trust and actually fill that up with assets. Super, super important. It's not just the paper that you created, it's really the second step is just as important, is transferring your house into the trust, your accounts into trust, or actually adding the trust as beneficiary as well. So let's just say Bill and Mary had a will. Okay, they did create that will, which is fine, but then Bill has a stroke and he becomes disabled. So just remember that a will only pertains to a situation upon death. It does not cover disability. So really, really important to be, create powers of attorney so that we can appoint people that will act on your behalf, either upon, for your healthcare decisions as well as your financial decisions. So Mary has to now get access to Bill's money, but she has to go see a judge first, and it's called a guardianship. So I joke about Britney Spears being in the news about her guardianship and conservatorship, but that's exactly what it is. A judge is in control over your personal life, where you're going to live and how much your money is going to go for, or who's going to be in charge of it and how it's being spent. So the court process is really designed to help people who are mentally disabled. Certainly we don't want anybody to be taken advantage of. However, it's quite expensive. It's quite time consuming. So when you go to guardianship court, the judge will have to meet the person and take the time to figure out who is in charge and who is the right person to deal with it. And then every single year, you're going to have to tell the judge, here's how much money there was for Bill, how much was spent, and basically everything that's happening with his health as well. You don't want the judge to have to be the decider of that. That's very personal, and it should be just your family dealing with that. So just by creating powers of attorney, that will be avoided from your family going through that. So let's say a couple of years later, Bill passes away, and what do we have to do now? So Mary, she has certainly worried about Bill and Bill's estate, and she has to figure out how to distribute the assets. So what happens in probate? Now she has to open up a probate estate. I mentioned earlier that as long as you have only you have 100,000 and above, so they created a will and they have at least $100,000 of assets. Now Mary has to open the estate, and really the probate estate is there to pay creditors, resolve disputes, eventually inventory everything, and then of course distribute it out. But even though those are the kind of the things that we're trying to accomplish, there's going to be some cost. There's going to be some time. So the expenses, I said earlier, 5 to 10,000 is not unusual to start that probate, to go start to finish. And then if there's more fighting, there's going to be a lot more cost. Time consuming. So minimum time is 6 months. But at the average, I would say in our office, about 1.5 to 2 years. So here your family is grieving and dealing with, the sadness of your death, and now they still have to keep going and dealing with the estate. It's also open to the public. So I'm very, very adamant about keeping things private, because once you have a probate estate, now everybody knows how much your kids are inheriting and where they live. So 2 pieces of information that you don't want in public record. And I get phone calls. I know the clients get phone calls, people trying to take advantage of your kids or your beneficiaries. The last disadvantage is multiple probates. So if you do reside in Illinois, but you have a winter home in Florida, we would have to open a probate estate in Florida and in Illinois. So now you've got just more expense. So now a couple of years, 10 years later, Mary passes away. What happens then, right? So she She has an estate as well, and their estate was about 1.4 million once Mary passed away. Now we talk about the kids. So earlier Mike talked a lot about, what if your kids get a divorce? What if your, kids are in having some difficulty? So we always worry about, is the child really ready for this distribution? And clients are worried about this. Someone will take advantage of them, or the kids are just not ready. I don't know about you, but I feel like the 20-something set, this generation isn't quite as ready as, from before. They don't have the financial maturity necessarily in their 20s. So I always think, let's try to broaden that time frame that they're getting this money so that they could make some not so great decisions in their 20s, but know that there's some money left over in their 30s and 40s, because parents are worried. These are the top 3 things that people worry about, that their kids might get a divorce. And now all of a sudden your ex-son-in-law has all the money or half the money. Somebody taking advantage of their kids. That's what I said with even a Bernie Madoff, or once you have an inheritance, all of a sudden people are like, hey, why don't you invest in this company or in whatever they're trying to promote. The third one is we just don't know. We don't have a magic, that magic 8-ball or the ability to know what's going to happen with our kids. So if they're in a lawsuit at that time, or they have a bunch of creditors at that time, we don't want to give them money and then all of a sudden it's going to the wrong people that way. So what happens? So what we generally would recommend is, why don't we create a trust? So we're talking, we talked about the will generally goes into probate, but the trust avoids probate. But secondly, we're able to put as much instructions as you want in the trust. Someone told me one time that I describe a trust like money with instructions. That's it. It's your instructions and it's coming from you. So for instance, with Bill and Mary, they have a trust, and upon Mary's death, we're going to give the money to the kids, but we're going to kind of put some restrictions on there so that they don't spend it quickly or unwisely, and then maybe they'll be able to save some of it, right? So with Susan, Bill and Mary trusted her. She was married. You gave her the money and give her an access trust, which means that she can have access to the money anytime, but it's held in trust. So if her husband files for divorce, guess what? That money is 100% hers, not half to the ex-husband, right? That's a big deal, and you want them to have that option. The other type of trust is the Century Trust, or this is the type of trust that's more restricted. So John, they were kind of worried about his employment prospects and whether he would even have a job or whether he'll stay out of drugs and alcohol, which he had a history of. So they have chosen, I'm going to give it to you, John, but I'm going to give it to you in like increments, right? And so you could be very customized on that. So I've had people say, as an example, if you're worried about money, too much money too soon, in his 20s, he can get up to $25,000 a year. In his 30s, $50,000 a year. And then maybe by the time he hits 40, okay, we'll give him a little more access to it. So you could do whatever you want. But bear in mind that when you keep it and held in trust, what's nice is you're protecting it from divorce and from lawsuits and creditors and things like that. So it's not just a gift, it's like a gift that's wrapped and has the protections. So why even create it, right? Why even create it? Well, it's creating a trust will give you peace of mind because it owns your asset and it becomes the standby device. So it protects your family and protects you in case you become disabled. You'll have the powers of attorney and the trust in place, and then you'll have the fiduciaries that you've chosen that will take care of your finances, whether you're disabled and certainly upon death. You'll avoid probate. You'll avoid court involvement. Who wants to have everything that they've worked hard for out in the open and be something that someone can take a look at? So the court won't be involved. And then last is it just protects your family, protects your even further generations. So a lot of people assume, okay, it's going to go right to my kids. But sadly, again, we don't know. You might have some grandchildren, and further, if one child is not around, then we know it's going to go downwards to the next generation, your grandchildren, which is really important. So very important to create that trust so that it becomes your kind of instructions in the event of your, obviously, a disability or a death. So in short, estate planning is all about protection. It's really about protecting your family, protecting in the event of a disability or death. And most people leave nothing behind as far as instructions. So how are they remembered? Well, they leave behind oh man, Dad didn't do anything, and now we're fighting, and now we don't see each other for anything, for family get-togethers at all. Or you could leave behind something that's like buttoned up, done within three to 6 months. Everybody gets their funds, and everyone is just generally content with how it all went, and they are not worried about the family fighting. That's really, I mean, not that it's that clean and dry. It's one or the other, but I've seen both, and believe me, people are much happier when everything's kind of in place. So that is kind of the end of the day. Have you seen both scenarios, Mike?
Yeah, Maritess, I think if you ask most parents what they would want if they're not there, it would be for their kids to get along, and for their kids to still see each other.
Yeah.
And you've mentioned a number of reasons why at the end of their life, and maybe they're looking down and they're seeing what's happening and they're thinking, that's not what I wanted to have happen. They wanted peace. They wanted everybody to get along. They wanted relationships, to still be there. Maybe it was mom, maybe it was dad that was the glue, and they want their kids to still be able to see each other and be family.
Yeah, exactly. And it's so, to me, that's more important, more important than the money. Certainly money is important, but I think the relationships of your family and what you've built, you've spent a lifetime building, your family dynamics and them, really seeing each other, different generations. I think that's so, so important.
The other thing that I will mention, and this happens in every profession, right? I'm just going to speak to your profession as an estate planning attorney. When any of us go to see a doctor and we leave, I think the people who speak most highly about what their experience has been, it's because not of the doctor's technical knowledge or how they help, you with some health condition or illness or whatever, but it's the way that they were treated. It's the conversation they had. It's their bedside manner and so forth. And in the estate planning profession, I will say this, Maritess, you and I have known each other a long time. Yeah. And I think everybody really appreciates you because of how you handle yourself and how you handle yourself around everybody that you meet. And so having that great bedside manner really helps. And I've known situations where clients have said, hey, Mike, can you go with me? Because I'm not sure that, I'm going to be able to understand everything that the attorney explains to me. And because it's being explained in a way that the language just doesn't make sense to them. But you really don't do that. And I think that makes a big difference as well. So
yeah, thank you. Thank you so much, Mike. I really appreciate that. And back at you, I know that you and Dale and your team do a great job of helping your clients. And that's why I think we have a very similar practice in a sense that we want our clients to understand exactly what they're getting into and not talk too high level where, they don't even, really understand what they signed and things like that. So I appreciate that. I think it's really important. Yeah.
And thank you for bringing up a variety of issues that come up where people don't really have a chance to think about, and giving people some food for thought. And hopefully those people who have been on the sidelines and thinking about doing estate planning are going to reach out to you or to us or to the specialist of choice to take action and execute that estate plan. So thank you again, Maritess, for being with us. And Dale, I'm going to check back in with you and see if we have some questions that can be answered for some of our attendees.
Thank you both. We do have a few questions, so we'll go through them. Those of you who are with us, if you want to submit something, again, use the Q&A button on your screen and we'll try to answer that. So a couple of questions. We'll start with this one. Somebody was asking just basically, what's the difference between an executor and a trustee?
That's a great question. So you are going to choose fiduciaries for your estate plan. And so that's the umbrella term for people who are acting on your behalf. So when you have an executor, that person is going to be named in your will, and their role is really only if we need to go to probate. The judge has to choose or appoint you as the executor because you're named there, and you would just sign all the court papers, make sure everything is done properly in probate. The trustee is the person that is going to be in charge of all the assets in the trust. So when the time comes and you need to sell the house, when you have to get access to a bank account, when you have to get proceeds from a life insurance policy, that person is filing the paperwork, making the phone calls. So it's a big role. The trustee role is a lot bigger of a role, but if you do your estate plan correctly, you'll not even need to have that executor act because you won't have probate and the trustee is the major role. I also point out that most people have the same person. I recommend same person because it's really kind of the same role in dealing with your finances.
Thank you. Another question. Somebody was asking whether or not a child needs a power of attorney when he or she turns 18 years old.
Yes, yes. So this is something every time I hear somebody's graduating from high school, I'm like, make sure they have a power of attorney. So the minute they turn 18, you have no say in their lives in a sense of being being able to access whatever information. So if your college kid is in a accident and the hospital saying, hey, your kid's here, they actually can't even you can't make decisions for your son or your daughter because they're 18. So I'm a huge fan of the minute they turn 18, sign here, son or daughter, and name the two of you, the parents, as the powers of attorney. That way you'll never have that situation, because it's a scary thing that you can't make a decision for your 18-year-old child, which is, by the way, not really, even though legally they're an adult, but I don't think they're ready to make those types of decisions.
Okay. Here's another question. Someone is asking, their parent is starting to get forgetful. And so at that point, can she still sign a will, he or she?
There's some factors to determine about what that forgetfulness is, and that's certainly a pretty big topic right now. Alzheimer's and dementia is on the rise. And because it's such a wide range of, are they in the early stages of dementia, or are they really obvious in the sense of not being able to make decisions? I would say the beginning stages, if they are starting to be forgetful, it's a matter of having a conversation with them. So I will have a conversation with the person, ask them questions, really see if they understand what they want and what they want to accomplish. As long as they understand it, they might not remember it for detail tomorrow, but as long as they understand, this is what I want my daughter to be the agent and I want my money to go here, then they can sign documents. Okay, but there's definitely a fine line. If there's ever a question about it, I'll generally ask to make sure, have they seen their doctor? I definitely have to be very careful about if there's any question about it. So it depends.
Okay.
So Maritess, just as a follow-up to that, if something was later contested, to say the person who executed the agreement was not of sound mind, would it take maybe a physician's sign off on that, or what would happen in that kind of case?
Yeah, because if it gets there and there's some contest to this, the situation, and it's in court, they're going to require some medical records. So they'll find out, how was this person at different stages. So certainly they could have, the person could have looked like they knew what they were doing, but a doctor previously has already signed off that they're, they're incapable. So there's a lot of factors.
So if there are any early signs and people haven't executed their estate plan, their will, their trust, and POAs or what have you, they should get that done sooner versus later, correct?
Yeah, absolutely. So if you think your mom or dad or aunt has signs of it and it's pretty like consistent, like it's not just one or two times, I would certainly have them write powers of attorney at the very least. I mean, they could do a will or trust, but the very least the powers of attorney, so someone can make decisions for them instead of going to guardianship or conservatorship.
We have one other question, and then we're getting toward the end of our time. So this question relates to someone who has beneficiaries on all or most of their various accounts. The question is, if that's in place, do they then also need a will?
Oh, good question. A lot of people, you know, they add their children or whoever they want to put in as beneficiaries to their IRAs, their 401ks, and their life insurance. That document is actually a contract between you and your company or the company that's holding that asset. That is gonna avoid probate no matter what. So it doesn't matter what you put in your will, what the beneficiaries say does go there. So with that said, yes, it's true, it makes it simpler, but if you have other assets like a house or, you know, a bank account and savings accounts, even if you have beneficiary designations on certain assets, you're going to want to make sure that everything else can get to the family. So you still need a will or a trust. Just don't rely on just beneficiary designations, because those people may not be there too. And then who does it go to? It goes through probate again. So beneficiary designations has a reason to have it, but there's some limitations to it.
Very good. Well, that, I think, completes our questions. So I will thank both of you for your time and for the great information that you've passed out. I'll thank all of those of you who joined us today as well. If you have other questions that come up as you think about this material or whatever, please feel free to reach out to any of us. We'd be more than happy to either correspond with you on a question or talk to you, you know, as long as you need. So with that, we will thank you again for coming, and we will be done. Thank you.
Thank you.
Thanks again.